Before I start the topic, that is types of trial in criminal law, I would like to give you some tips on criminal practice as such. Because earlier, this program was named as Continuous Legal Education Program. We were entertaining or we were allowing an advocate who has already completed 7 years of practice or up to 7 years of practice. But now we have taken the decision to enlighten those advocates who have just enrolled with the Bar Council. If I mistake not, this program is to all those advocates who are enrolled with the Bar Council since January 2020. That means all of you are new entrants to this noble profession. And therefore, we have also changed the name of the lecture series as BLEP from CLEP. That means Basic Legal Education Program. As all of you are very new to this profession, some of you must have joined some senior, some of you may not have till joined senior. And therefore, there should not be any frustration to all of you as to where should I go, to whom should I contact, how I can practice, to whom I should seek the guidance. All these questions we must be in your mind. And therefore, friends, it is not necessary that your father must be an advocate, your uncle must be an advocate, your maternal uncle must be an advocate, your brother must be an advocate. That is not at all necessary. What is necessary? Three principles are necessary for developing the advocacy, for getting success in advocacy, is that you must show hard work. First thing you must remember in mind is the hard work. Second thing is the integrity towards the profession. And third thing is the honesty to the brief. If you keep in mind these three things, I don't think that there will be any obstacle for you to continue as a successful advocate and make your career as a successful career. Now, therefore, I would like to give you some more few tips so that it will be helpful to you. First thing, as soon as you enter the court, you must first join an office of a senior advocate. Why I am saying so? Because as we all know, because I have also gone from that thing, that nobody will entrust you a case, maybe it is a murder case, maybe it is a rent possession case. Everyone wants some senior advocate to conduct his case. And therefore, unless and until you make yourself an identity in the society, the people or the client will not dare to hand over the case to you. And therefore, my dear friends, by joining an office of a senior, what you will get? You will get an opportunity to see number of cases. You will get an opportunity to see variety of briefs. You will get an opportunity to seek guidance of the senior. You will get an opportunity to discuss your problems with the senior. And therefore, joining an office of a senior is the first thing you must do. And the basic thing in joining an office of a senior is that the notion of you will be clear. In so far as criminal law is concerned, the notion factor plays an important role. One second. Mr. Ganesh Pawar.
Yes, sir.
I think that all of them have not muted their microphones. Well, mobile ringtones and all that I am listening here.
I think, sir, now it is clear, sir.
Now it is clear? Thank you. Okay. Somebody is watching TV by mistake now. Okay.
Muted all. Muted all.
Okay. Thank you. So I was on the point that your notions must be clear. That means approach to the facts of the case. How to approach a case? If you read the facts of the case, what is your interpretation to the facts of the case? How you take the facts in your mind? That is important. It is also important to get proper interpretation, proper analysis of a particular law, particular section, particular statute. And therefore, if you interpret either a statute in a particular way, if you interpret a definition in a particular way, whether that is the proper interpretation of what you have interpreted is very much important. And in the initial stage, if you lose concentration on this, if you don't make the proper interpretation of a particular section or a law, then that will be the mistake for your entire life. And therefore, by joining an office of a senior, you will be guided by the senior that no, this is not the interpretation of law. Or yes, what you have interpreted is a proper interpretation of law. And therefore, the first thing to join CFA, senior's office. Second thing, attend the court regularly. Now, I find many juniors, if I hand over them a brief and ask them to conduct, they just remain absent for weeks together. Now, that you should not do. Because if you attend a particular case on day one and you skip the session for second, third day, and you join the session on the fourth or fifth day, you will miss the link. And therefore, attending a court regularly, maybe your senior is there or not. If your senior is not there, that is a good opportunity for you. You just take over the briefs, read it properly. And that is the time when you can have your own time to read the brief. And therefore, attending a case, attending a court regularly, now you see people are watching you. The clients are watching you. The clients are paying attention as to who is a regular advocate. It much depends upon regularly coming in court. You may be having a case or not, but you must attend. You must sit at a proper time, at a proper place. So that will help you a lot. So attending a court regularly is the second aspect on which you must concentrate. Because your senior must have interested you some work, and if you skip that work, that will impact not only on the case, but on the client also. And by joining an office of a senior, by attending the court regularly, third thing you should do is that you should read out the brief of the day. That means, suppose if there are 3 to 4 matters of your senior on a particular date, try to read most of the briefs. Because if your senior sometimes asks you to seek an adjournment, and if you go to the court with the adjournment application, naturally, you must at least know what is written in the application. You must try to convince the court that what is the reason given in the application and how that application reason is proper application. Sometimes the judges will ask you, yes, I will grant you an adjournment, but let me see as to what are the facts of the case. Can you tell me what is the case? At that time, you should not say my senior is coming or my senior will explain you. That should not be the answer. So reading the briefs properly, regularly, will create an impression on the court also. And the court will also tell your senior that this particular junior is studied junior, is reading the brief, and he knows each and every facts of it. Even in many times, it may happen that the senior may lose the exhibit here and there. At that time, the judge may ask you, yes, Mr. So-and-so, you tell your senior what is the exhibit. At that time, if you have properly read the brief and you have grasped all the facts and you have taken down all the exhibits, suddenly if you answer the exact exhibit number, that will create a very important impact not only on your senior, but on the judge, on the client also, that this is a studied man. Now, going to court, what you have to do is observe the situation. Now, you have already read the brief. Now, observe Now, I will try to tell you so far as criminal cases are concerned, because civil side is not my subject today. And therefore, from criminal point of view, criminal case point of view, I am discussing or I am sharing my views with you. Now, attending the court regularly, attending the senior's office regularly, you have now already grasped the contents of the brief, the facts of the case. Now, by going to a court, you observe the prosecutor. Now, how he takes the examination chief, which witness he has examined, and what is the purpose of him examining this particular witness. If you pose a question in your mind, ask your senior as to why he has chosen that witness when there are other witnesses on this point. You discuss this aspect with the senior. Once the exam comes, and as soon as the examination chief begins, you must have now noted that your senior will start writing the examination chief in his own handwriting, or the senior will ask you to write the examination chief. Don't become a mere scribe at that time. Try to grasp as to what was the important point he has taken in examination chief, and on what points we have to focus our cross-examination. And then observe the cross-examination by your senior. If the case is adjourned after examination chief, take the copy of the examination chief, sit in the office, focus on the points of cross-examination, take out the point, show it to the senior, and discuss with him on which point we are going to cross. On the next day or at the next attempt, when your senior starts his cross-examination and finishes his cross-examination, you must have learned that on what point, how he has falsified the important points narrated by the witness in the examination chief. And therefore, you may think over now that what points I have calculated or what points I have taken, my senior, whether he has touched those points or whether my senior totally omitted my point. If the senior totally omitted my points, you should ask him as to why this question was not important. Or if he has taken other points, you should ask him as to why you have taken those points. By this way, you can develop the cross-examination. I will give an example as to how a cross-examination is done by the senior advocates. When those were the days when I was in college. I was studying in Pune, but in summer vacation, I had been to Solapur. And as my father was a public prosecutor, there was an infamous, I may say that murder of an infamous personality, an Namchin Gunda, what we call, had taken place in a broad daylight in big square, in the main chowk of Solapur. And that trial was to begin. There was flash of news, there was wide publicity in the newspaper regarding the proceedings and all these things. And therefore, I thought I must also join the trial. Therefore, I went there. The case of the prosecution was that in a broad daylight, that fellow was murdered in a chow, just few feet away from his house. And after the assault took place, someone went and informed this fact. Someone went to the house of the victim's wife and narrated her the incident that your husband is lying in injured condition in a chow. She hurriedly went there and she saw the husband is in severely assaulted, is in very bad condition, and therefore she started alarming people, Vachwa, Vachwa. Thereafter some people gathered, all of them took him to hospital. After a gap of 4 to 5 hours of treatment, thereafter that fellow died. In the entire night, no complaint was filed. On the next day morning, after the cremation and all that thing, the complaint by the lady was filed with the allegation that when someone told me that my husband is lying in injured condition in a chowk, when I went there, I asked him as to what happened, who has assaulted you. At that time, my husband narrated me that these accused A, B, C, D, they have assaulted me. And accordingly, she has given the complaint. That is the case of the prosecution. Now, this lady being an important piece of evidence for the prosecution, they were heavily banking on her evidence. And after the examination in chief, I was and the entire courtroom was curious as to what will be now the cross-examination from the side of accused. late Mr. Vijayarao Moite, a senior advocate from Pune, was engaged by the accused person. He started his cross-examination. First of all, he posed certain questions in order to show as to how the deceased and the accused were not going well with each other. He showed some questions that how it is possible for all these persons to involve these persons. So background he created. But the main task was to disbelieve the so-called dying declaration, because it will be a dying declaration. Whatever last words uttered by the deceased relating to his cause of death, so far as the definition under section 32 of the Evidence Act, will become a dying declaration. And therefore, this dying declaration was to be falsified by the cross-examination. So Mr. Vijayarao Moite started his cross-examination. Vijayarao Moite, I am very much impressed by his cross-examination. Very soft-spoken person. And what you call in Marathi, की लहान मुलाला चमच्याने जसं पाणी पाजतात चमचे चमचे, त्या पद्धतीने ते एक एक प्रश्न विचारत गेले. प्रश्न काय विचारला? I will tell you in Marathi because it will not be convenient, or it will not, you will not also would like to hear it from English language. So he started, हे बघा भाई, तुम्ही ज्या वेळेला तिथे गेलात त्यावेळेला तो अत्यंत जखमी अवस्थेमध्ये फक्त विवळत होता. आन्सर इज हो. देर आफ्टर तुम्ही लोकांना ओरडाओरडा करून गोळा केला आणि तुम्ही त्याला घेऊन रिक्षातून सिव्हिल हॉस्पिटलकडे निघाला. हो. रिक्षातून जाताना तुम्ही फक्त रिक्षावाल्याला लवकर चला, ह्याला वाचवायचं एवढंच बोलत होता. बाकीचे 2 लोक सुद्धा एवढंच बोलत होते. हो. रिक्षातून सिव्हिल हॉस्पिटलमध्ये जाईपर्यंत तुमच्याशी नवऱ्याचं कोणतंही बोलणं झालं नाही. जेव्हा हॉस्पिटलमध्ये तुमच्या नवऱ्याला ठेवलं, जेव्हा त्याला आतमध्ये इंडोर पेशंट म्हणून घेतलं, तुम्ही बाहेरच उभे होता, तुम्हाला आत जाऊ देत नव्हते. आणि त्यानंतर 4-5 तासानंतर तो मृत्यू पावला असे डॉक्टरांनी तुम्हाला सांगितलं. त्यानंतर दवाखान्यामध्ये पोलीस आलेले होते. पोलिसांनी तुमच्याकडे चौकशी केली. तुमची काय तक्रार आहे का म्हणून विचारलं. तुम्ही त्यावेळेला कोणतीही तक्रार दिलेली नाही. आणि त्यानंतर दुसऱ्या दिवशी सकाळी अंत्यसंस्कार झाल्यानंतर तुमचे सगळे नातेवाईक गोळा झाले. त्यांनी सांगितलं की हा आपल्यावर फार मोठा अत्याचार झालाय, अन्याय झालाय. हो. आणि मग त्यांनी सांगितलं की तुम्हाला बाई आता पुढे व्हावं लागेल, तुम्हाला म्हणावं लागेल की माझ्याशी तो बोलला. हो. आणि म्हणून तुम्ही सांगताय की तो तुमच्याशी बोलला. हो. Now this was very lightly, very in a simple tone, question by question, he went on asking and the lady went on answering in affirmative. So in spite of this, the case ended in conviction. Now ultimately in High Court, it was acquitted. But I have given you this example as to how he has focused on the dying declaration and how he has falsified the dying declaration without going in the knowledge of the witness. कळलं पण नाही त्या बाईला आपण काय सांगतोय. So this created much impact on me while cross-examination. Then I will point out that I have gone through a book of a noted advocate, Mr. Ramakant Olekar from Thane. I request all of you to purchase that book. The book's name is That's All, My Lord. That's All, My Lord by Ramakant Olekar from Thane. Now, what is this book? He was a noted criminal advocate from Thane. He has given number of cases, incidences in his book. He has also mentioned as to how he has taken instructions. He has also mentioned how he has cross-examined. He has also mentioned how he has made out his defense. What were the circumstances, what were the factors he has taken into consideration, and how those circumstances have helped him in developing the cross-examination, and ultimately how he has succeeded with the brief. Now, the important thing which he has mentioned in the book, and the one which I am following till today, and I request you to go through the book, and if you like that style, you also can follow that style. What he has mentioned is that read the examination chief or the 161 statement or 154 statement, for example, of an eyewitness. Take out the points for the cross-examination. Pose certain questions as if you are a witness and then ask certain question to yourself as to, and then what will be your answer to that question, and that answer should be in the affirmative. म्हणजे स्वतःला त्या विटनेस म्हणून पोच करायचं, क्रॉस एक्झाम आपणच करायची स्वतःलाच प्रश्न विचारायचा आणि आपण काय उत्तर देऊ यावरून त्या प्रश्नाचा मोड, त्या प्रश्नाचं फॉर्मेशन हे बदलायचं, जेणेकरून आन्सर इट इज ट्रू म्हणूनच येईल. आणि असे प्रश्न हे ऑफिसमध्ये प्रत्येक केस मधल्या मुख्य पॉइंटवरचे चक्क लिहून काढायचे, की ते प्रश्न त्याच फॉर्मेशन मध्येच त्या विटनेसला विचारले तरच आन्सर अफर्मेटिव्ह येऊ शकतं. हे 4-4 वेळा स्वतःला उलट सुलट विचारून खात्री करायची आणि मग तो प्रश्न लिहूनच काढायचा आणि मग कोर्टात गेल्यानंतर बाकीची क्रॉस परिस्थिती पाहून करायची. परंतु हे प्रश्न लिहून आणलेले ठराविक पद्धतीनं, ठराविक वेळेला, ठराविक पॉइंटवरती त्याला विचारून आन्सर आपल्या बाजूने घ्यायचं. सो इफ यू डू दिस, you will develop the skill of cross examination. I will give you a number of examples in the latter part of our discussion, but basically remember this thing, that cross examination is the gist. हा क्रॉस एक्झामिनेशन हा केसचा पाया असतो, ज्याच्यावरती संपूर्ण केसचं भवितव्य हे अवलंबून असतं. देन आफ्टर द क्रॉस एक्झामिनेशन, देन कम द टर्न ऑफ आर्ग्युमेंट. At the time of argument also, you should prepare your own written argument, not at my stage, but at your stage. That you should prepare notes. You should show it to the senior. Sir, these are the notes of my argument. And then attend the court, see the argument, hear the argument of both the sides, whether your senior has covered the argument of the points which you have mentioned. And if not, then discuss. After the argument, when the judgment comes, then read the judgment. I found many juniors who don't take care as to what judgment is written. They are only interested whether the case is acquitted or not. Now, why I am saying so? Because the points which you have urged before the court, whether he has accepted all your points, whether he had turned down your certain points, if he had turned down your points, why he had turned down your points, and if he has accepted your point, why he has accepted and appreciated your points. Now you will find, you will come to know, if the judgment is in your favor, then it is all right. Still, if some points are not appreciated, try to develop those points in the next case. If the judgment is against you, then what is the angle taken by the judge while rejecting your case or your points of argument? Take it seriously, read it again and again, and then try to develop it in next case or in appeal stage. And therefore, if such study is done by you, these are the tips for you, junior friends, that these will help you. Now, always try to grab the opportunity, because I already told you, no one will give you a new case. Try to grab the opportunity. How you will grab the opportunity? Because sometimes some person, they engage you. Now, don't be afraid. I will give you an example of myself. Because I am a BSc Agriculture. My father was a prosecutor. When I started practicing, or when I intended to start practice on criminal side, because for civil matters up to 2:30, 3:30, the matters would have over, and I was rushing to my farms, because my farm is about 3 to 4 kilometers away from my residence and office. And therefore, as there was ample time with me, I used to go to farms. I used to grow vegetables and all these things. So nearby farmers of my farm, I had a good friendship with them. On one day, one murder took place in that locality. So the young boys, they were arrested. So the nearby farmers, they came to me. And that was the period when I was in practice for just 2 years. Evidences, and the matter will be in your hand. And therefore, somehow I studied your internet connection. Somehow I studied the matter, and you will believe me, not only the circumstantial evidence was destroyed, but the investigating officer was issued notice by the court that you have prepared the entire evidence falsely. So this was the opportunity which has given me and hope. This was an opportunity which has given me a boost. And from there, I started handling cases. Thereafter, one more example I will give and then we'll turn to the topic that I had an opportunity to conduct a triple murder case. Till that time, my 7 years practice was finished. Now, when the persons came to me, they had been to many stalwarts from Solapur. All the stalwarts had rejected that case. I said, why they are rejected? The client said की त्यांची फी आम्हाला परवडत नाही. दुसरा म्हणाला की नाही नाही केस अवघड आहे, फाशीची केस आहे. So they came to me. When I have gone through the brief, I found that the case is the evidence collected by the investigating officer is worth not believable. And therefore, although they paid me some meager amount, I accepted the challenge. I was knowing that if I succeed in the case, then that will be success last long. But if I fail in that case, as a criminal lawyer, my career will be finished. But that opportunity had been to me. As those persons wanted to engage me, in spite of the knowledge that I'm a junior advocate, I took this opportunity. I prepared the case. And not only this, the height is that when I stand before the court, when the prosecutor was about to open the case, the judge asked as to who is going to defend the case. I stood up and said, yes, myself going to defend the case. The judge demoralized me by saying that you are going to conduct this case. This is a hanging straight away. फाशीची केस आहे ही तर तुम्ही चालवता एखादा सिनियर घ्या. That demoralized me, but still I said, sir, मी अभ्यास केलाय आणि बघतो मी प्रयत्न करून मला. The judge said, बघा बाबा तुमचं नशीब. Then the matter started. The matter was like that. There were a number of eyewitnesses and there was also a dog track evidence. But when I read the brief, I found that if at all the police party had summoned the dog track, that means up till that time, nobody had witnessed the incident. And that's why dog was summoned. And if dog track was summoned, sniffer dog was summoned, then what was these eyewitnesses doing up till then? So I cross-examined the eyewitnesses on that point, showed the court that these are all got-up eyewitnesses, falsified the dog track evidence because when the sniffer dog was summoned, up till then, the entire material lying on the spot was collected by, was seized by the police machinery. That means they have handled all these stones and other clothes and all these things which are bloodstained. They have handled, and the policeman who has handled all these things, he has given the smell to the sniffer dog. And therefore, question is how a sniffer dog has recognized that smell and barked to the accused. So that point was also appreciated, and the matter ended in acquittal. And therefore, I got a huge publicity in that case. Ultimately, the state prepared an appeal, but the appeal is also dismissed, and that case is reported. You can see State versus Ashok Atkar case. State versus Ashok Atkar. So, my friends, the opportunity comes only once in life. You have to show number of juniors are there who 40% of the briefs with me are coming through juniors. I always ask them, why don't you conduct the matter? If the client is paying 100 rupees fee, the entire 100 rupees are belonging to you. Why you are expecting some cut practice? You are giving me 100 rupees. You are expecting something from me. I, as a friend of you, I also know that I must pay you something. Then what is the use of just satisfying yourself with some amount of that out of that 100 rupees when 100 rupees are out you? So develop this habit to conduct the case yourself. Not only observe your senior, but observe the style of other seniors also. Take good things because one senior may be good in cross-examination, one senior may be good in arguments. Take all those points, collect all these things, develop your own style, and that will be the masterpiece for your success as a criminal lawyer. So, my friend, these are the studies, these are the some points the most important thing to become a good criminal lawyer is that you also must know civil law. Because many times the murders and all these things they take place because of the dispute of the barn. There is some civil litigation pending. There is some injunction suit is filed. There is possession is claimed. So what is the possession? As to who can be said to be in possession? What is 712 extract? What is 6D? What is 8A? All these are mentioned in the 712 extract and in the revenue records. You must know that what is known as wreath, what is known as vaivat. By vaivat, whether a possession of a person can be held to be true. So these things, this civil aspect, civil angle study will help you in developing your criminal law practice also. So you must know all these things. So my friends, the small tips which I have just given you, I hope that they may be helpful to you. Now let us start our topic of today, that is types of trial in criminal law. Now, you see that there are three stages so far as the criminal trial or criminal law is concerned as to how it develops. There is a pre-trial stage, there is a trial stage, and there is a post-trial stage. Now, you will ask what is the difference? Pre-trial stage means a stage which is set up up till the matter is fixed for hearing before either a sessions court or a magistrate court. So, what is necessary for pre-trial? What is pre-trial stage? What are the necessities for coming to the court as a trial? At least some offense ought to have been committed. For example, A assaults B with a knife and injures him. Now, assault by A to B with a knife, injuring him. What will be the offense? The offense will be voluntarily causing hurt to others. So what will be the offense? Offense will be 324. Now, whether 324 is a cognizable, non-cognizable, Mr. Ganesh kindly show the definition of section 2C, cognizable offense. An offense described in first schedule. Sorry. Section 2C describes cognizable offense. Means an offense for which means an officer of a police station. The offense described in first schedule under any law for the time being in force, and wherein a police officer can arrest without warrant. And a non-cognizable offense means an offense for which a police officer has no authority to arrest without warrant. Now we have filed Mr. B has filed the complaint with the police machinery. So according to section 154 CRPC, the officer in charge of a police station will take down the complaint. As it will be a cognizable offense, he will try to arrest the accused also. He will start his investigation. He will try to seek the corroborative piece of evidence, whether there are other eyewitnesses who have witnessed the incident. He will record their statement under section 161 of CRPC. He will send the injured to civil hospital. He will collect the medical certificate to corroborate the fact that he was really injured with the knife by A. And after arrest and then of course remand and bail and all these things, I will not deal with that aspect. But one by one, I am trying to tell you as to how a pre-trial stage occurs. Then after collecting the entire evidence of statements, medical certificate, the chemical analyzer report, if the officer finds that this is a fit case to send a charge sheet, he will send a charge sheet to the honorable court. Then what the magistrate will do? Magistrate will take cognizance of the case, and if the case is a warrant case or a summons case, accordingly deal with the case. The definitions are given in section 2X and section 2W. So warrant case is a case relating to any offense punishable up to or above 2 years. it includes the death, the life imprisonment, and all these things. So far as summons cases are concerned, relating to an offense not being a warrant case. So these two things are important. Now this was, so far as the cognizable offense is concerned, the police investigation is concerned, the sending of charge sheet is concerned. Now next example is that A assaults B, or rather A slaps B on his cheek. Just slapping. So what will be the offense? The offense will be 323. What is that offense? It is a non-cognizable offense. Now all friends should also refer to the first schedule wherein classification of offenses are shown. Whenever a case comes to you, whenever a bail you wanted to do, you first see the classification of offense. A particular offense is a bailable, a non-bailable, a cognizable, a non-cognizable, and triable by a magistrate or triable by a sessions court. And now I was dealing with the second example, that A has slapped B, a non-cognizable offense, and if B rushes to police officer, as happened in earlier case, what the police officer will do? The police officer will tell him that I don't have any power to arrest him. This is a non-cognizable offense. So I will not take cognizance of it. I will not register the case against A. Of course, section 155 of CRPC gives him power, if at all he wished so, that he could seek the permission from the magistrate, and then accordingly he can investigate the matter. But normally, I would say normally, the police officer in a non-cognizable offense, they don't interfere. They just ask the complainant, यातील फिर्यादी यांना हुजूर कोर्टामध्ये परस्पर फिर्याद देण्याची समज देण्यात आली. They will write, they will take the contents of your allegation, and then they will write, they will get acknowledgement and send you back. So what is the option for this man B? So this man B has an option that he has the option to file a complaint, private complaint, to the magistrate. Now what is complaint? Kindly refer section 2D of CRPC for definition of complaint. Complaint means any allegation, oral or written, to a magistrate with a view to his taking action under the code. That means if anyone goes to magistrate and alleges that I have been assaulted or there is an injustice to me, this is the oral or maybe written, then and asking him to take action because police has not taken action against that fellow, kindly take action against him. So what are the options of the magistrate? The magistrate will then record statement of Mr. B and take evidence if at all B adduces. And after seeing the evidence, if he is satisfied, then he will proceed with the case. If he is not satisfied, he can straightaway dismiss the case. Or another option for the magistrate to send it for inquiry under section 202 of CRPC to the same police machinery. And the same police machinery, if from the orders of the court, if they start the inquiry and they found substance, then having the evidence of some witnesses and other things and all these things, they can again send a report to the magistrate. And if the magistrate don't send this to the police, and if after inquiry or after getting adduced the evidence from the side of complainant, the magistrate is satisfied that yes, this is the case by which I can take cognizance, the magistrate can straightway issue process against Mr. A. So these are the two pre-trial stages. The first stage, wherein we have seen offense under section 324, the police report has come up to the court. That means from police to magistrate, this pre-trial, so far as 324, we have seen. The police to magistrate and magistrate taking cognizance, we have taken example number 2, section 323, and now the magistrate has taken cognizance and magistrate has acted. This is the pre-trial stage, so far as private complaint is concerned. And then these are the two examples. So section 324, it will be an offense punishable up to 3 years. So that will be treated as a warrant case. So the definition which we have already seen. And so far as offense under section 323 is concerned, that will be treated as a summons case because the punishment is below 2 years. So these are the two stages, two types of cases, summons case and warrant case, which have now reached to the court. And now what the court will further see, the court will see if it is a police case, that whether the police machinery has given the entire copy as narrated under section 207 of CRPC to the accused persons. As of right, the accused person has the right, because how he is going to defend the case. And therefore, when the copies are given to the accused, it contains the FIR, the statement recorded under section 161, the documentary evidence, the public analysis report evidence. All these evidence has to be given free of cost to the accused for his defense. Now, suppose, as we have seen 324, a warrant case, suppose a charge sheet, that means a report, comes so far as offense under section 302. Because that is the first issue which we are going to deal, a trial before a court of session. If a charge sheet under section 3, sorry, section 302 comes before the court will first see that will be sent to the court of session for trial, because the classification of offense in schedule mentioned 302 section as triable by court of session, and therefore the magistrate has no authority to keep the matter with him. He has to commit the case. So now this has come up to pre-trial stage. The charge sheet has come. The magistrate has converted the case into warrant case, treated the case as warrant case, summons case, and now the sessions case. The case has gone to session case. This is how the case come to session court. Now, dear friends, here, before we start dealing with the trial before court of session, one thing is to be remembered, because all of you are new entrant, just 1 or 2 months. You must be all watching movies in Hindi cinemas and all these things. Every movie now and then has a court scene. And therefore, don't get impressed with those court scenes. They are only meant for entertainment. Of course, sometimes there is some logic. Because yesterday, at the time of inaugural session, Justice R.C. Chavan has also quoted or also advised you to see those two movies. That one, Jolly LLB, second or first, and Kaida Bola. So, because there is some logic, some point is there in the movies, so far as court scenes are concerned, court matters are concerned, which we must take into consideration. Now, I will give you an example in a movie in which always I see such type of movies. I am fond of movies, such type of movies which has a court scene. Now, there was one movie in which, if I mistake not, name was Mary Jung, in which the actor, that means the actor in leading role, he was a lawyer. And he was handling a case that the fellow who died has not died because of the consumption of poison. So what he did, in the courtroom, the police machinery which has collected the bottle as a poison which was consumed by the deceased was seized by the police machinery during the part of investigation. So this fellow advocate was harping that this is not a poison, I can prove that. What he did was, he just took the bottle in front of the court and drank the entire bottle and sat there for 15-20 minutes. This somehow convinced the court, and the court said, thereafter, after the court gives the verdict, he rushes to hospital. So this is not the logical point. That whether this was a poison or not, sending it to chemical analyzer and all these things. So these things we should not take, because those things do not happen in our court. The second case which I saw was also important case. Have you seen the movie Aitraz, in which also there is a court scene? And in that court scene, the actor has dragged the actress in the court under under a charge of sexual assault. Totally reverse case. What we usually find is that the lady they file a case of sexual assault against the male person. Here the actor filed a case against the lady, that means actress, of sexual assault on him by them. So the Mr. Paresh Rawal, who has done the role of advocate, very intelligent cross-examination. If you have not seen, please kindly see this for the questions what he was posing. One question I like very much is that he was cross-examining the actor because in examination chief he told as to how he was sexually assaulted and all these things. He asked him, what was your position when the sexual assault was going on? He said that lady was down and I was I was above her. That means he was in dominating position. So he just posed the question to the judge, मिलॉर्ड ये देखिए जिसका बलात्कार हो रहा है वो ऊपर था और जिसका बलात्कार हो रहा है वो ऊपर था. And he laughed in a very big manner. So that was the logic, that was the point he was trying to impress the court. A very good point he tried to make, because ordinary man will say that this will not be position. The fellow will not be in a dominating position who is receiving the assault. And therefore, these are the part of entertainment, because in movies they always show that at any certain time anybody comes in court and says that, my lord, this is the witness, and then the judge asks, जो भी कहना है आपके कटोरे में कहो. These are not the stages in court. Of course, in one of movie it was shown also that the judge was about to pronounce the judgment. At that time, one witness comes and the witness evidence is taken, and the verdict is reversed. Although Section 311 CRPC permits any party to recall a witness for the just decision of the case. That means you can summon a witness at any time, but you must satisfy the court that it was for the just decision of the case. So that on that basis, that was the logic also. And therefore, there are stages given in the court of law. There are stages given in a trial before a court of session. Now let us see what are those stages and how we are going to deal with those stages. Now, trial before a court of session, the topic number 1 of today. Now you will find trial section 225 CRPC quotes that trial is to be conducted by the public prosecutor only. Now, who is public prosecutor? For that purpose, you have to see definition of section 2U of CRPC. Section 2U says one who is appointed under section 24 of CRPC is a public prosecutor. Now, who appoints the public prosecutor? It is the choice of the government. Although there is a committee as prescribed under section 24, that committee of district magistrate and district judge, they will quote 2-3 names, and amongst them, one of the named person has to be appointed as a public prosecutor by the government. That is what law expects. The condition is that the public prosecutor must have an experience of at least 7 years. So if anybody from you wanted to become a public prosecutor, wait for 7 years, study hard, and then try to become a public prosecutor. It is a status symbol post. My father was a public prosecutor for 16 years. It is a prestigious seat. And therefore, why the public prosecutor is asked by the legislature to conduct the cases only? Because the session trial cases are all serious cases, like murders, like rape, like dacoity, like attempt to murder, and so on. So the state will take care of the aggrieved person, and there should not be an injustice to the aggrieved person, not only to the aggrieved person, but to both the sides. This particular provision has been enacted by the legislature by mentioning that only the public prosecutor will conduct the case before a sessions court. Now you may pose a question Then when the private case, as narrated by my, when the private complaint was filed, because I have given you an example of section 323, slapping a case. त्याच्याऐवजी जर अटेम्प्ट टू मर्डरची केस असेल, समजा चाकूनी मारलेला असेल, छातीत मारलेला असेल आणि पोलिसांनी जरी केस घेतलेली नसेल आणि अशा वेळेला वकिलांनी ड्राफ्ट केलेली केस जर कोर्टामध्ये आणि कोर्टाला वाटलं की सेशन ट्रायलला जायला योग्य केस आहे, देन दॅट फेलो विल से that I have engaged my lawyer has intelligently drafted the complaint, and now because of his drafting and because of his convincing the court, my case has come to the sessions court. Although the police were not taking cognizance of me, I have knocked the door of the court. My lawyer has taken much effort, and therefore I want my lawyer to conduct my own case in a session court. Whether that is permissible? The answer is no. For that purpose, you have to see section 301 subclause 2, wherein it is specifically mentioned that the entire prosecution before a court of session has to be conducted by a public prosecutor, and the fellow, that is the advocate who has drafted your complaint so nicely, so skillfully, and who has made the court to commit the case to the court of trial, and that's how your case has come to the court of trial, has only to assist the public prosecutor. And at the ultimate stage, at the time of final argument, the private advocate can seek the permission of the court and file written submissions. Now, there are a number of judgments on this point, that whether at the time of bail also the private advocate has an opportunity to plead his case when public prosecutor is there. There are judgments wherein it is categorically held by the honorable court that no, it is for the prosecutor to argue. And if the private person has some more evidence than what is placed before the court by the public prosecutor at the time of bail also, then and then only he can submit the case and convince the court that whatever evidence the prosecutor has shown to the court is short of evidence. I am having much more evidence than that. Kindly see me, police are not taking my evidence, and this is the evidence by which your honor may get convinced not to grant bail to the accused person. So these are the rulings which you must go through. And therefore, so far as trial is concerned, you have to assist the public prosecutor. That is the law finally. Then what is the role of public prosecutor? Now, my advocate of my choice is not given a chance to conduct. Whether the public or prosecutor will do his duty, whether he will conduct the case properly. So the legislature has also cautioned all the public prosecutors. It is expected from the public prosecutor that he should assist the court in coming to proper conclusion. It should not be the sole motto of a public prosecutor to seek the conviction. But the prosecutor should see that fair justice is done to both the parties, and by which his conduct, by his evidence, justice is given to the bereaved. This is what is expected from the public prosecutors. Now, my father was a public prosecutor, a stalwart advocate, having mucked up all the laws, all the case laws, having an authority in the law. He used to say, whenever there is no case for the prosecution, he used to fairly say, the prosecution has no case, your honor may acquit the case. At one time, at one juncture, it so happened, the case was being conducted before a principal district judge. My father fairly quoted whatever evidences he read out, and he said that these are not the evidences helpful to me, to the prosecutor, and therefore kindly take into consideration and kindly do justice to the case, and your honor may acquit the case. The judge was angry. He said, are you a prosecutor or a defense lawyer? My father said, yes, I am a prosecutor. Then you are submitting that the case should be acquitted. He said, yes, I am submitting that the case should be acquitted. The district judge asked, should I write it in judgment that you have conceded you have mentioned that it should be acquitted. My father said, yes, Your Honor may write in the judgment that I have conceded. Then my father showed him number of case law. One of the case law you may take down, Sandeep Kumar Bapna versus State of Maharashtra. Sandeep Kumar Bapna versus State of Maharashtra, wherein the role of a public prosecutor is specifically detailedly described, analyzed. It is observed by the Honorable Court that it is not his duty to go on seeking conviction, but he must be fair. He must assist the court in coming proper conviction. It so happened in one case, I had an opportunity to witness the facts of the case. My father was a prosecutor. A murder of a wife had taken place. Husband has committed murder by pouring kerosene and then lighting her in his own house. Thereafter, hurriedly, he took her to hospital. Thereafter, the wife was 100% burned because right from top to toe, she was burned. In the hospital, he gave the history. Doctor asked how she is injured. He narrated that she was working on a stove in a kitchen. Somehow the stove blasted and she has received a injury. Accordingly, history was taken. Police were summoned. He threatened the wife to give a statement like this. Accordingly, wife given the statement that it was because of the explosion of stove, I got all this. Thereafter, magistrate was summoned. Before magistrate also, she gave the same version that because of the explosion of stove. Then the parents came. They took her in confidence. They asked her, what is done? What has happened exactly? She narrated that my husband and he has set me on fire. Thereafter, again the magistrate was summoned. Again the dying declaration was taken. That was the third dying declaration in which she said, no, my husband had done this mischief and he interruption. The defense lawyer laughed at me and said, why your father has produced those two dying declarations? Now my case is on more footing, on better footing. I asked my father as to why you have produced those two dying declarations. They are against you. What you are going to gain by producing those two dying declarations? He said, just watch. It is my duty to produce all the documentary evidence which the police have collected. The case was opened. The defense harped upon first two dying declarations and argued that, see, this is a clear-cut case of accidental death. My father started his argument and he submitted the code to kindly see the spot Panchanama. In spot Panchanama, there was no whisper of seizure of any stove. On the contrary, in the spot Panchanama, there were stains of kerosene. So what does this show? This negated the theory of explosion of stove. And therefore, he argued that first history is given by the husband. The lady was in the custody of husband. The husband took her to hospital. The first entry is given by the husband. And therefore, the explanation of the lady in the third dying declaration that because of the pressure of my husband, I have given first two statements as accidental is accepted by the court and ultimately the accused was convicted. So I was on the point of role of public prosecutor. Fairly, my father produced all the documents. In spite of that, he sought the conviction. So this is the duty if you are going to become a public prosecutor. Nowadays, it is very much difficult for the public prosecutors to act like this. But if the man is of principle, जर तुमच्या मनात काय खोट नसेल, if you are a man of integrity, honesty, then you should not fear anybody, but you should give justice to the victim. So this is what was told by my senior. Then you will find that after the role of prosecutor, he opens the case. That means, in short, he narrates the case to the section 226 is the opening of the case. It is only in sessions cases. In short, he quotes the honorable court as to what is the charge, what is the evidence with him, and how he is going to prove the evidence. Hello? 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 Am I audible? Yes. So I was on the point that thereafter the prosecutor opens the case. In short, he has to tell the court as to what is the charge against the accused, what is the evidence with him, and how he is going to prove the charges against the accused. So after hearing the opening of the case, after hearing the facts, reading the brief, hearing the defense, if the court finds that it's not a case in which a charge can be framed under section 227, the court can very well discharge the case. I will give you certain examples. I had an opportunity to conduct such cases wherein in one charge sheet, the entire evidence, the entire witnesses were saying, yes, I have heard that B's murder is committed by A. Entire charge sheet was saying like B's murder is committed by A. Now, from where you have heard? Who told you? Who has seen the murder? Nothing was there. Understand as to how the police submitted the charge sheet. The court also felt that how such type of charge sheet is submitted. And therefore, if there is a such case like this case needs to be discharged. This is number one. Number two, in which case, all witnesses were saying 5 years back, there was quarrel between A and B, and therefore, A must have committed murder of B. Entire charge sheet was saying 5 years back, there was quarrel between A and B, and therefore, A must have committed B's murder. So this was the evidence. Again, the court discharged. Because by seeing the papers, by seeing the 161 statement, evidence, all these things, if the court finds with the assistance of prosecutor and defense that there are no evidence of charges to be framed, so at that stage the court can discharge the accused and there is no need for trial going further. So remember section 227, apply your mind to the facts of the case, and if you are in a position to show to the court whatever evidence has been collected is of no use to the prosecution, but taking the evidence as it is, the case will not going to end in conviction. You can certainly file an application for discharge and you can argue the matter before the court, quoting the facts of the case in a manner which are favorable to you. And therefore, once you show to the court that this is the case of discharge. The third example is in anti-corruption cases. Many times the public, you may see section 197 because the public servants who are trapped for taking the bribe, they are prosecuted. But for their prosecution, for submission of charge sheet, sanction of the authority who has appointed or who has power to remove is a must under the act. And if no sanction is there, you can certainly file an application for discharge. And at that time, you can convince the court, see, this is the basic lacuna in the case of prosecution. Although the sanction and all this can be filed at a later stage and all this thing, law is there, but you must make an attempt to convince the court that, see, this is the case wherein my client can very well be discharged. And therefore, taking into consideration these things, this is a stage wherein the discharge can be sought. Now, if discharge stage is over, if your man or your accused is not discharged, then comes the stage of framing of charge, section 228 CRPC. Now, what is essential, if you are dealing a case of sessions case, what is important is that you must see what is the charge frame against you. I have found many juniors as well as seniors even the prosecutors, because sometimes the court gives a draft charge, they just give the office give the draft charge, they charges, and the matter is initiated or matter is started. Don't do that. You just go through the charge and see section 211 also, which is framing of charge. What does this show? It shows that it must have the total description. That means the accused must have a knowledge as to what I am going to defend or what needs me to defend my case. So the contents of the charge super 211 is that in clear terms there must be allegation as to who has committed the murder, on what date he has committed the murder, at what time he has committed the murder, for what reason he has committed the murder. All these things are done by him with intention and knowledge. All these ingredients, as expected under section 211, must be there in the charge. Maybe you are a prosecutor or you are a defense lawyer, because the charge can be altered at any time. If you don't point out these things, you must assist the court while framing the charge. Because tomorrow, if you conduct the trial and ultimately if the court alters the charge and it has caused prejudice to your defense, then you have no voice. And therefore, pay an attention to the charge. I will give you an example of a famous case of the actor Salman Khan. Now, you all know him, that there was a case against him, hit and run case. So, what was the charge against him when the police submitted the charge sheet? The charge against him, it was alleged that he was in drunken condition and he drove the vehicle in rashly and negligently and thereby causing death of number of people sleeping on a footpath. And therefore, the police collected the evidence, and while sending a report under section 173, the police submitted charge sheet under section 304A, causing death by negligence, which we generally found in a case of accident. Causing death by negligence, because accident is not a case which a person will do it with intention. की एखाद्याला मारायचं ठोकायचं म्हणूनच केला आणि मग तो ऍक्सिडेंट आहे. Accident is an accident. By circumstances, you can judge. Although one may cause a death with a car, but and wanted to commit murder, he may pose like that. But that matter is different. But in an accident case, normally the police charges 304A, which is available of it. But in this case of Salman Khan, the police charge sheeted him for an offense punishable under section 304A as well as 304 part 2, culpable homicide not amounting to murder. Now, there were battery of lawyers defending the actor because he is a big shot fellow. All lawyers applied their mind and they filed when the case, because obviously 304 part 2 being a session triable case, the case was committed to Court of Sessions. So at this stage, before framing of charge, what I pointed out earlier, the lawyers, they filed an application for discharge or rather for deleting section 304 part 2. Arguing that the matter is of clear accident, where is the question of causing death with intention or with knowledge? And therefore 304 part 2, how it will be applicable to the facts of the case? They agitated this matter. The Sessions Court rejected their contention. Therefore, the actor went in High Court. Revision was filed. Again, battery of lawyers argued the matter. And ultimately, the High Court got convinced of the fact that it is a clear case of accident and therefore 304 part 2 needs to be deleted. So accordingly, that section was deleted, ordered to be deleted. State government filed an appeal against the order in the Honorable Supreme Court. The Supreme Court said that at least there must be some evidence before the court to show that whether there is a 304 part 2 or whether there is. Now the police have sent a charge sheet. The police are having some evidence. They are having the blood report and all these things. And therefore, prima facie, why not a charge under section 304 part 2 can be framed? If no case is made out, you may be acquitted. And that's how the case was again remanded. And ultimately, the matter was tried with the charge under section 304A as well as 304 part 2. Accordingly, he was convicted. Thereafter, he filed an appeal in the Honorable Bombay High Court. ultimately appeal was allowed. So these are the basic laws which you must deal with, and therefore kindly note down the case Salman Khan versus State of Maharashtra. Sorry, State of Maharashtra versus Salman Khan, reported in 2004, CRLJ, page 910. I repeat, State of Maharashtra versus Salman Khan, 204 CRLJ, 910. At this juncture only, I advise you that this is a stage of beginner. You go through all the journals. How to read a journal? You have an ample time. Your senior must be having a full library of all the journals, or maybe one or two journals. At least read out one single case every day. What you should do, read out the case of your interest. Just don't go on a head notes. If you found something there in the head note, you just go through the entire facts of the case, how the court had dealt with the matter, what were the points, how the honorable court has come to the conclusion. And if you found it to be a fit case for your background for conducting a case, just make a note of that particular case in your notebook or your laptop. Nowadays, all people are technical people, advanced technology. We used to write, I still have a notebook wherein still I used to write whatever case I read. If I found it proper to be helpful to me, I write it. Not only just write those cases, but after 2 months, 3 months, open your diary and again read the cases so that you will come to know what cases you have written, and those cases will be fixed up in your mind. So that will be helpful to you. So do it from today if you have not done it. So, dear friends, I was on the point of charge and discharge, and then comes section 229. If after framing of the charge, if the court asks the accused that I charge you that you have committed murder of Mr. A, do you plead guilty? Suppose if normally 99% or rather in 100%, there is a rarest of rare case wherein the accused says, yes, I plead guilty. But in majority of the cases, the accused says, I don't plead guilty, I claim to be tried. But that is not a general, that is all right. That happens regularly. But you have to apply your mind when an accused pleads guilty to a murder case, then what are the options available to the court? Suppose you come across with a case that your accused says, I want to plead guilty. Then what are the options to the court? Can a court accept his guilt and accordingly convict him in a charge under section 302, which is having a severe punishment of death or life imprisonment? For that purpose, you have to go through section 229 of CRPC. Conviction on plea of guilty. What does it read? It reads, if the accused pleads guilty, still discretion, the word discretion is there. Still there is a discretion whether to convict him or not. That means the legislature has expected or has cautioned that even though a person pleads guilty for severe offenses like murder, rape, or dacoity, or attempt to murder, all having severe punishments, the judge has given a discretion, and normally or regularly, I would say, if a person pleads guilty, no judge will use the discretion to convict him, but all the judges uses the discretion to be tried, that he should be tried. He will ask the prosecutor to go on with the case. Now, an important point is that when the court has asked the prosecutor to lead evidence, will you not pose a question before you? What is to be tried now? The accused has pleaded guilty, and that is my evidence. I will base my conviction on this admission. If you are a prosecutor, you will say, yes, my lord, he has accepted the guilt. Why should I adduce the evidence? And in what capacity the judge can give the direction to me when he has pleaded guilty? For that purpose, you have to see section 58 of the Evidence Act. You see, for studying law, merely because there is a topic that trial before a court of session, we can read those sections and we will be in a position to learn all. That is wrong. These three major act book has to be marked up by you. Now, section 58 of the Evidence Act. What does it quote? Facts admitted need not be proved. No fact need to be proved in any proceeding which the party thereto or their agents agree to hearing, or which before the hearing they agree to admit by any writing under their hands or rule of pleading in force at the time. That means facts admitted need not be proved. Accused has admitted, we need not prove, the prosecutor may say. But still, the legislature has made a provision under section 58 proviso. What does it read? It reads, provided that the court may in its discretion, again the discretion. We already read out the discretion in section 229. Again a discretion, require the facts admitted to be proved otherwise than admission. And therefore the judge will say, it is my discretion, I have accepted his guilt, I have accordingly written that he has pleaded guilty, but still it is my discretion that you must prove the facts of the case. And that's how the further stage will come, that leading the evidence. I think this point is very much clear to you now. And therefore, friends, if you are a prosecutor or a defense lawyer, you should have overall look of all the laws, because you should not show your ignorance by saying that yes, he has admitted, there is no need for me. You cannot file a procedure by closing the evidence. That is not expected. And then comes the further part of section 231, evidence for prosecution. Sorry. Evidence for prosecution. Now again, it is for the prosecutor now to prove his case by leading the evidence. The court gives you a date and the prosecution will proceed to take all the evidences which are supportive to the prosecution. Now what is that stage? One by one the prosecutor goes on examining the witnesses. Now what is the procedure? Examination chief, cross-examination, re-examination, as you must have seen this, where it is mentioned. For that purpose, you have to again go back to section 137 of the Evidence Act, wherein the examination chief is described and the order of examination chief, cross and re-examination are mentioned in section 138 of Evidence Act. Now, big question is that the prosecutor in his examination chief is not expected to ask leading questions. This is very important. What he has to do, he cannot ask a witness that, for example, गोविंदराव तुमच्या घराजवळ राहतात ना, श्यामराव त्यांच्या पलीकडेच राहतात ना. Now this question, गोविंदराव तुमच्या घराजवळ राहतात ना, has suggested the answer that yes, गोविंदराव माझ्या घराजवळ राहतात. Answer is clear. So this is leading part. So don't do this if you are a prosecutor or you are would-be prosecutor. So the example is that you cannot ask a leading question. Then the legislature says that if the adverse party, if so desires, can cross-examine. So cross-examination is not compulsory to each and every witness. If it is for you to decide. If you are a defense advocate, it is for you to decide whether to cross-examine a particular witness. Now, why so? Because many times, according to our defense, many things are admitted to us. And if the prosecutor examine any such witness, for example, the inquest means a panchanama of a dead body. Normally, we, the defense lawyers, admit it. And if the prosecutor, on some other angle, wanted to take the pancha of inquest pancha, we need not cross-examine. And the judge will also say, you are admitted, why you are cross-examined? So it is the choice, it is the sweet will of a defense to cross-examine, it is not compulsory. Now, important part of the case, as I quoted earlier in this lecture, is cross-examination. Now, for cross-examination, I will give you 2-3 examples. How a cross-examination is to be taken. On what point you should focus. Now, for example, I dealt with a case wherein a murder was committed. How a murder was committed? Murder was committed by strangulating a person and then hanging him on a tree, posing that he has committed a suicide. Now, there were 2 eyewitnesses to this case. Now, these 2 eyewitnesses' claim was that they have witnessed this incident, these accused persons strangulating and then posing the dead one as showing that he has committed suicide. Now, their case was that on the fateful day, they were farmers. And it is their case that it was a cloudy situation. And therefore, as I wanted to cover my crops in the field, I went to the field because this incident has taken place at about 9 p.m. in the night. So I, on a motorcycle with Mr. B, the other eyewitness, we had been to my field. We covered the crops so that they should not get damaged from the rain, would-be rain, because the atmosphere was cloudy. गडगडाट येऊ लागला असं म्हणत नाही का, गडगडणं चालू झालं होतं म्हणून आम्ही आमच्या शेतातलं पीक झाकायला निघालो होतो. आणि परत येताना while coming back on the barn, because the deceased land is on the way to my land, and therefore I happened to saw that these persons were strangulating him. And thereafter I went back to my house. That is the case of the eyewitness. Now, important point to focus in examination chief is that whether there was need, whether this fellow was having a land which was having a road by which he has to pass from the land of deceased, number 1. Number 2, whether there was crop in the land of this fellow which needed to be covered from the rains. Because the story put forth by him was that because of that cloudy situation, I need to go to my farm. But whether really there was a crop. Now, important thing is that you have to dig up the accused persons. Because I have found many times, the accused persons, most of them are in jail. The persons who come to give you instructions, they are rather reluctant. What is their feeling is that we have given your fees. It is for you to see the defense. It is for you to collect the document. It is for you to decide fate of my case. If you go on asking them whether this fellow is having a land, you please bring the 712 extract. They will say, I will try, but they don't turn up. They just turn up at the time of trial. And therefore, digging up the instructor, that means the fellow who comes to you, pursuing him, taking follow-up with him, is very important. What was important in this point is that, what I was trying to harpen is that whether the road passes from the land of deceased. And for that, I asked them to bring the village map. Because they were saying की ह्याचं शेत तिथं नाही आहे, हा तिथून जात नाही. I said, कसं आपण दाखवणार कसं? नाही, आम्ही सांगतो की अहो तुम्ही सांगणं शब्दाला शब्द देऊन काय कोर्ट आपला ऐकणार आहे का? Bring some document. And therefore, I forced them to bring the village map. And when the map was opened before me, we found the land of deceased at eastern corner and the land of this eyewitness in western corner. So there was no need for this fellow to pass from the land of deceased and to witness the incident. This is number 1. Number 2, I asked them to bring 712 extract of 2-3 years. what crop he is taking. They were saying त्याची सगळी बागायत जमीन आहे, त्याच्याकडे काय सगळं बागायत क्षेत्र असतं. I said, bring the 712 extract. So when the 712 extract of the year on just preceding the year was brought to my notice, I found that the entire peak pani, that's why I initially mentioned की 7-12 सुद्धा तुम्हाला कळला पाहिजे. त्या 7-12 खाली पीक पाण्या म्हणून नोंद असते. त्या पीक पाण्याच्या इथं ह्या आय विटनेसच्या इथं नोंदी होत्या की ऊस संपूर्ण जमिनीमध्ये ऊस होतो. Now you will see that sugarcane is a totally irrigated crop, and sugarcane needs more and more water. It has no need to cover the crop from the rains. And therefore, when I started my cross-examination, I pinpointed him that, see, this is your 712 extract, and you don't have any such crop which needs to be covered. I showed him the village map, brought the situation and record that there is no road which passes from your land to the land of deceased by which you can get an opportunity to witness the incident. And thereafter, the cross-examination on the point of his natural course of conduct, that he has not informed the deceased, although he was staying in the same lane. He was just watching the TV, watching the movies, and all these things were brought in the cross-examination. The court was also asking him, ki काय तुम्ही असली घटना बघून नुसते पिक्चरच बघता का? He didn't inform the police. After 4 days, he informed the police. Yes, I have witnessed. And who was he? He was the son-in-law of DC. And who was the fellow sitting on as a pillion rider on his motorcycle? He was the brother-in-law of the first eyewitness. So merely because they were relative, the court was not going to discard their evidence. Because the Supreme Court has cautioned again and again, the person interested, their evidence need not be taken out merely because they are interested witness, but their evidence needs to be scrutinized from minute angles, from minute particulars. And therefore, merely because they were eyewitness, I was not banking on that point, but I banked on these 2 points, discarded their evidence, and that's how we got the result. The second example is a second example. Because nowadays all cases are POCSO and all these things. There is a presumption under law that whatever charge sheeted, the accused is charge sheeted, he has committed a guilt and all these things. There is a presumption under law. And that's why it has become more and more difficult for us to tarnish the case of the prosecution, because the entire thing lies in favor of the prosecution, the victim. One case I will quote you. A case, of course, POCSO and all these things are tried in a sessions case. Therefore, I had an opportunity to deal with this case. A matter was like this. There were 2 sisters. I am telling you all this on the point of cross-examination, where to harpen, where to attack, and what is to be shown to the court, how to disbelieve the witness. Two minor girls, they claim that they were sleeping on a terrace. And at that time, these accused went there. He pulled up the bedroll or the cover-ups, and he tried to outrage the modesty by uttering ki apan asa karo tasa karo. Thereafter, she made hue and cry, and thereafter she informed this fact to the father, because the father was in the shop. It was at 9 p.m. Both the sisters, they were sleeping on a terrace. His father was in shop. The mother was not. She was abandoned by the father. There was some dispute between the father and mother in the court of law. And therefore, the persons who were present in the house were only these 2 minor girls. The father was sitting in the shop. And at that time, this fellow went there and he outraged the modesty. That is their case. So I saw the Panchanama. I noted that the staircase which was there for going to the terrace was from inside the house. I asked the accused to take out the photographs from outside the house in order to see whether there is any chance for this man to enter upon the terrace from outside. He brought those photographs. We were convinced that there is no place to climb from outside. The only way to go to the terrace was from inside the house, from the staircase. And therefore, keeping in mind that we must show to the court that there is no opportunity for this accused to go on the terrace because it was at certain height, because nobody could climb also. There was no such chance of climbing also, that all these things were taken out in the Panchanama. So the main point was that to discard the evidence by showing that this fellow couldn't reach the terrace. The Panchanama itself mentioned the staircase was from inside the house, and therefore it was our duty to show that no access to this fellow to enter the house. And therefore I started my cross-examination. I took the situation of the ground floor. There were 3 rooms, 1 kitchen, 1 hall, and 1 bedroom. I asked as to where all the important things like your ornaments, your cash, and all these things you kept. They say in the bedroom we used to keep, there is a cupboard, there is a locker, and all these things. When those days were July month, it was a rainy season, and therefore there was no chance for these ladies to sleep on the terrace. That was also our point. Importantly, the father is outside the house. These girls are sleeping on the terrace, and therefore it was for me to lock the main door house to be latched, either from inside or from outside, so that I wanted to show to the court that this fellow had no opportunity to enter the house. So I asked the question to her that you being 2 ladies in the house, you were sleeping on the terrace, your father was outside the house. Now what you do? अशा परिस्थितीमध्ये तुम्ही घराला आतून कडी लावता का तुमचे वडील बाहेरून कुलूप लावून जातात? This was the question posed. Now you see the maklashi in this question. The only option given was that की आतून कडी लावून जातात का बाहेरून कुलूप लावतात? And she felt in the trap. She said की आम्ही आतून कडी लावू. And therefore the picture was clear. आणि तुमचे वडील आल्यानंतर मग तुम्ही काय करता? वडील आम्हाला खालून हाका मारतात, मग आम्ही टेरेसवरनं खाली येऊन कडी काढतो, मग आत वडील. So the point number 1, it was a rainy season, no chance of them sleeping on the terrace. Point number 2, there was no access for this fellow to go. And point number 3, that there was a political dispute between the party, that is father and they had contested, the father of accused had contested election against the father of the lady, and that's why this was the outcome of the case. So all these points are very much important, which you must apply your mind. The judge obstructed the prosecutor by saying, show me the access to go to the terrace. Then and then only he tried to convince him कि उडी मारून जाता येते and all these things. The judge said there must be evidence to that effect. You can't surmises by presuming things in your favor कि असा असू शकेल, you cannot have. So these were the points which you must take into consideration while cross-examining. Very simple things are there. Apply your mind. Common sense you must keep in mind. Presence of mind and common sense. These are the 2 things important for conducting a session trial, maybe a warrant case, maybe a session case, maybe summons case, maybe summary trial case. The answer to the case of the prosecution always lies in the papers given by the police magistrate. So study those aspects very minutely, and you will find an answer in the charge sheet itself. If not, you have to dig up your client, and then you can make out your case. Now, cross-examination is another point. Section 231 subclause 2. You can defer the cross-examination. Now, so what is the deferment of cross-examination? That means, as I told you earlier, it is not compulsory for you to cross-examine the witness. So also, legislature has given an opportunity to us. If you go through section 231 subclause 2, it will point out the judge may in his discretion permit the cross-examination of any witness to be deferred, or witness, or witnesses have been examined or recall any witness for further cross-examination. So deferment of cross-examination, deferring the cross-examination. What is this? म्हणजे सरतपास झाल्यानंतर लगेचच जे क्रॉस करायची असते त्यावेळेला तुम्हाला न्यायालयाला असं सांगता येईल का की आम्हाला ह्या क्रॉस एक्झामिनेशन ह्याची आत्ता नाही करायची, आम्ही नंतर ह्याची क्रॉस करतो. कॅन यू डू लाईक दिस? Certainly you can do like this, and that's why there is a provision to that effect. Now, how to take advantage of this provision and when to take advantage? And what is the role of a judge? What he has to see while allowing your application? What the prosecutor has to see while opposing the application of deferring the cross-examination is very much important. Now, I will give you an example. In murder, in rape cases, normally or in most of the cases, the complainant, that means the fellow who has set the law in motion, by filing a complaint under section 154, is normally a father, a mother, a brother, or sister, or other witnesses, to whom the victim has narrated that A has committed this mischief on me, this assault on me. She has disclosed this to father, mother, or other person, and those persons go to police station and they file the complaint. So what will be their complaint? Their complaint is that I was out of station, or I was out on my work. When I came back to the victim girl, my girl was weeping, and I asked her as to what has happened with you. She told me that this fellow has committed sexual assault on me. And accordingly, the father files a complaint. And thereafter, the police records the statement of the victim under section 161 and under section 164, if they desire. Nowadays, it is compulsory under the POCSO and all these things, before a magistrate. So, a wise prosecutor will always put the complainant in the witness box first. Why? Because he wanted to extract the defense from the side of the defense of the accused. Because the complainant is a formal complaint, naturally the accused advocate will harpen him as to why you have filed a case against me, and his defense will be open. And that's why a wise prosecutor will put a complainant into the witness box first. But at that time, if you have taken notes of your case properly, and if you want your defense not to be opened through the mouth of complainant, you can take advantage of this section. You can very well file an application. Sir, the examination chief of the complainant is over. I will defer the cross-examination up till the examination of the victim, because it might open my case. In such situation, the judge, if he sees the position, he may allow your application. I have done this in many cases, and I have tried to convince the courts that, see, if the victim, if they put the victim in the witness box earlier than that of complainant, I am ready for cross-examination. But if they go otherwise, I will defer the cross-examination. And I will cross-examine the victim first and then cross-examine the complainant, so that my defense will be perfectly put up in the way which I want. This is example number one. In murder case also, in many cases, the complaint is formal, the eyewitnesses are thereafter examined. So you have to open your case before a complainant, and therefore you can ask to defer the case of the prosecutor. But this is from the angle of prosecution as well as from the angle of defense. But what the court has to see, because you will find by deferring the cross-examination, many times the defense wins over the witness. There are chances of winning over the witnesses because an opportunity is given. Not that because in examination chief, he or she has narrated the strictly in favor of prosecution, that does not mean that you cannot win over the witness. So that has to be taken into consideration by the judge, that whether there is a seriousness in the application put forth by the defense, or whether there is a bad intention on the part of defense to one over the case, one over the witness, that is to be seen by the court. And these principles are well decided. And what will be the time consumed in these two witnesses? Time consumed in the witness of complainant as that of and that of the victim, that has also to be taken into consideration by the judge. Now all these things are well scrutinized, well judged, and very well taken into consideration in the case of State of Kerala versus Rashid. I repeat, State of Kerala versus Rashid. You go through this case and you will find as to what is to be done, what are the principles the Honorable Supreme Court has taken care of before filing the defer application. The prosecutor also must go through, the defense also must go through, so that you will be perfect so far as section 231 subclause 2 is concerned. Then the examination chief is over, cross-examination is over, re-examination. Now, what is this re-examination and when it can be taken? So, re-examination is the right of the prosecutor. The prosecutor, if any new thing is brought on record by the defense, and if the court feels, or if the prosecutor convinces the court that this new material brought in the cross-examination has to be explained by me, then he can seek the permission of the court. And he can again ask in re-examination the witness the things which are developed in the cross-examination. Because cross-examination has a very wide scope. It should not be restricted to the facts which are narrated by the witness in examination chief. You can take the surrounding situation, you can take the overall picture, you can try to discredit the witness, you can bring out record his antecedents, you can bring on record as to how he is interested in the case of prosecution. Many things are there, a wide scope is there, and therefore if any new thing which needs to be explained, then the prosecutor has a right to ask for the re-examination. Then what are the chances of defense then? Because whatever material we have brought, the court is get convinced that court has allowed the prosecutor to take re-examination. So he will wash out my whatever I have brought it on record. So there are again chance to the defense. If any new material, totally new material is brought on record by the prosecutor in the re-examination, then the defense can again cross-examine the said witness on that particular point. So these things you must keep it in mind while you are studying the brief. So far as examination chief, cross, re-examination, its scope, deferring the witnesses, all these things you must go through. Then comes when the evidence of the prosecution is over, then comes the stage of 313 CRPC. Now, what is 313? 313 is a stage wherein the court will ask the questions to the accused directly, wherein you need not step in, wherein the defense advocate cannot interfere. It is a dialogue between the court and the accused. And what is its effect? Suppose you have cooked up the case very nicely. Now you have totally dominated the case. Now you feel that your case is under full control. And if in section 313 questions, if you are accused, of course you have to give instructions to the accused that he need not answer all true sections. If at all he give false answer, that is also not going to damage him. But he should not admit certain things which are going to be asked by the court. Because what will be its effect? That has been given in section 313. Now the section 313 says the answers given by the accused may be taken into consideration at the time of judging evidence. May be taken into consideration. Now may be taken into consideration if the prosecution is in a position of proving certain things and your accused admits those things, then what will be the case? what will be its result? Now, I will give an example that in the infamous case of General Vaidya, which has happened in Pune, one Jinda and Sukha, they were the accused. Our colleague Mr. Nimbalkar has conducted the case. In that case, the eyewitnesses were stick up. They were examined. But in 313 statement, Jinda and Sukha, the accused persons who were ultimately hanged till death, they admitted the things. Yes, we have done the crime. Yes, we are belonging to that party. Yes, we are raised the Solam. Yes, our motto was that. Yes, we were here for committing the murder. So all were shocked. So what will be its use? Lower court took into consideration, the matter went up to Supreme Court. Ultimately, Supreme Court has held in that case that the said admission by these accused persons amounts to confession, and therefore they acted upon that, and accordingly they were convicted. So whether that will be the correct position of law is still debatable, because in many cases the Honorable Supreme Court, one of the famous cases you may take down, 2007 CRLJ taken into consideration. So all these things are debatable. After the evidence of the prosecution is over, after the statement of accused is also over, now it is your turn to enter into defense. Section 233, entering upon the defense. Now what is to be done? The role of prosecutor has come to an end. Now it is for you to decide whether to examine any witnesses in defense. This is a very important stage of the case. Now I advise you, the basic principle of law is that the prosecution has to stick up his case. Prosecution has to stand up or fall on its own case. The heavy burden is on the prosecution to prove their case. Now, if you want to say, or if you want to examine the witnesses by way of defense, and ultimately, if that evidence is falsified in the cross-examination of the prosecutor, then that will act as a boomerang on you. The case which you have put up, the defense which you have taken, the admissions which you have taken, will all go in water, will all be waste. If you take the decision, so be firm that the witnesses which you want to examine are firm witnesses. The witnesses which you want to examine are the witnesses which will be helpful to your case, which will be helpful to your defense. Then and then only. Now, for example, if the case of the prosecution is that you have committed murder of A, Mr. B has committed murder of A in a Chowk and Solapur. But if there are instructions with you, if you are defending B, B says, sir, I was not present in Solapur on that day, at that time, but I was present in Pune. There is a CCTV footage. I was shopping at that time. So this becomes the concrete evidence. Now, because of the technical error, you can very well point out that you are not present here. You can summon that footage and all these things, and then you can take the evidence. Many times in earlier days, when there was no technical development, the accused person used to say us, sir, I was not present in Solapur. I was staying in Pune. I was staying in one lodge. These are the receipts of the lodge. You can examine the lodge, man. So such type of evidence was rather not convincing to the court, because the lodge receipt and all this, even though you don't stay in the lodge, you can very well get it. That is all within the knowledge of each and every person. And therefore, such fishy evidence, such evidence which do not inspire confidence, must not be taken. Now, I will quote you an example of case wherein on a bus stand, a murder had taken place. So, when to take a defense evidence and when not to take a risk of examining the defense witness. Murder on a bus stand in a village had taken place. Now, unfortunately, no witness from the bus stand from that village were available with the prosecution. Only one witness from the nearby village was summoned as a witness. His case was that on that day I had been to a relative in that village, and while returning back, I was standing on the bus stand, and in before me I saw A committing murder of B. So that was his evidence. He was the sole eyewitness of the case. And therefore, he being a resident of just 2-3 kilometers away from that particular village, and when he has said that I had been to my relative in the village, no name of relative was given. So while seeking instructions, I asked the persons as to whether really any relative is there in your village of this witness to whom he claims to have come on that particular day. Earlier, initially, they were reluctant. They were saying, no such relative is there. I digged up again and again, asked them. Then they came and said, yes, one Mr. Rangnath Patil from our village is a long relative of him. There, then I said, whether Mr. Rangnath Patil will support our case, will say that he never had been to me. Somehow they convinced Rangnath Patil, and then we took him as a defense witness. So we took an examination chief by quoting that this eyewitness is my relative, but a distant relative. माझ्या आत्याचा नामचा तो पाहुणा आहे. माझी आत्या मरून 5 वर्ष झाली, तेव्हापासून त्याचं माझं जाणं येणं नाही. आणि घटने दिवशी काय तो माझ्याकडे आला नाही. That was our examination chief. Now what happened? Eyewitness is a chance witness. He is not hailing from that village. What he claims that the reason he is giving to visit that village is because he wanted to visit this relative. This relative in defense saying that yes, he is my relative, but he never had been to me on that day. So doubt is created regarding presence of this fellow on that day on a bus stand. So this type of witness helped us. In another case, a murder had taken place of a fellow in the courtyard of his house. His wife was out of house. His minor girl was posed as an eyewitness. She was just 9-10 years old, a school-going girl. And the case started. The mother explained that, yes, I was not there. When it was a school going time, so she must be present in the school. So I asked my persons to go in the school, see the master, whether really she was present in the school. They said, yes, we did saw she was present. I asked whether present is there. They said, yes. I didn't believe them. I personally went in the school. I saw the master. I asked the headmaster the situation. They said, the master says, we are ready to depose. Accordingly, we summoned the headmaster, the class teacher, and the one student from the class. 3 witnesses we examined, and we succeeded in negating the contention of the minor girl. So you should not go on taking the defense witnesses every time, but if at all they are helpful to you, then and then only you can die. The point which I wanted to tell you, so far as cross-examination and all these things, one more thing is to be added as to what is not to be asked in the cross-examination. This is important. You can have a general denial because it is for the prosecution to prove the case. But so far as cross-examination is concerned, you should not ask such questions which will be filling the lacunas of the case of the prosecution. For example, normally there are cases of 498 and 306. The parents come and they say, माझ्या मुलीचा खूप छळ होत होता. ती आम्हाला नेहमी सांगायची की माझा खूप छळ करतात आणि म्हणून तिने आत्महत्या केली. नाउ दिस एक्झामिनेशन चीफ इज जनरल अँड व्हेग. काय छळ करत होते, कधी करत होते, मुलीने कधी सांगितलं, नथिंग इज देअर इन द एक्झामिनेशन चीफ. बट डोंट बिकम एन्थुजियास्टिक इन क्रॉस एक्झामिनेशन. तुम्हाला सांगता येतं का कधी छळ केला? हो सांगता येतं की हे घ्या तारखा. तुम्हाला सांगता येतं का काय छळ केला? हो सांगता येतं की उपाशी ठेवत होते, मारत होते, टोचून बोलत होते. Now, there was no necessary for you to ask these questions. These mistakes are generally committed in the earlier days because you may feel की आपला क्लायंट मागं बसलेला आहे. तो म्हणतोय की आपल्या वकिलांनी काय विचारलंच नाही. विचारायची गरज नाही. कारण का सर तपासातच काय आलेलं नाही. तेव्हा क्रॉसमध्ये विचारायची गरज नाही. त्यामुळं काय विचारावं यापेक्षा काय विचारू नये याला जास्त महत्व आहे. Once I conducted a case, one junior fellow was with me on behalf of accused number one. The case was like this. The eyewitness, she was sleeping in a courtyard. Accused persons came there. They poured kerosene, they lighted the house in which the parents of the lady who posed herself to be an eyewitness, they were sleeping. So double murder was committed. Sir, her examination chief was so vague. She just narrated. ते आले, त्यांनी रॉकेट टाकलं, पेटवलं, मी बघत होते. My junior friend who was defending accused number one was enthusiastic. He went on asking, ते आले तुम्हाला कसं कळलं? She said ते कुजबुजत होते, आवाज आला, बोलायचा आवाज आला म्हणून मला कळलं. कुजबुजत होते, काय बोलत होते? She said ते रॉकेल कुठं आहे, काडेपिटी कुठं आहे, सांग. So all these things were taken on record which were not there in examination chief. So it was very difficult for me to falsify all these contention. Somehow in the cross examination, I pointed out those were rainy days. The entire day there was rain, so she could not sleep in the courtyard. Number one. Number two, the Panchanama shows the kerosene and all these things were inside the house and no stains of kerosene on outside the house. Therefore, there were no chances of pouring kerosene from outside and then lighting up. So these are the cases wherein you should take care of the things as what not to be asked in the cross examination. Then comes the point for argument. Last point. Now, prosecutor will sum up his case, try to convince the court. What arguments, how you should advance the argument. Now, argue on the points initially which are favorable to you. Don't argue on the matters which are unfavorable to you. Because the judge is rather impatient. He has to deal number of cases. What was in the mind of the judge, you don't know. You should get his attention to your arguments by quoting the points which are favorable, which are appealable to the court. And then once you harpen upon that point, the judge will get convinced and then you attack on the minor points. Case law, not necessary to point out in every case. Case law is there. My father used to say, only point out case laws on law points. की त्या केसमध्ये 4 जणांनी मर्डर केला, ती केस सोडली. आमच्यात पण 4 जणांनी मर्डर केलाय म्हणून आमची केस सोडा. अशा फॅक्ट्सवरती केस लॉ कामाला येत नाही. Don't show such type of case law. And if once you show a wrong case law, it will create a bad impression on the court. And the court next time will say, काय मिस्टर थोपडे, केस लॉ दाखवला तो बरोबर आहे ना, तुम्हालाच लागू आहे का नाही? And therefore, although it is necessary to point out a case law, but it is not always necessary to point out the case law. Now, the points of argument, you have to prepare your argument, and by seeing the mood of the judge, always keep notes of written argument, because nowadays the judges are not passing the judgment on time. I have a very experience of getting the judgments after 1 year, 6 months, 8 months, and therefore I have taken a practice to, after finishing oral argument, because oral argument is the best convincing argument. You are in a position to convince the judge only by your oral. The written arguments may not get the judge convinced, and therefore argue the matter orally and then try to submit written notes of argument to the judge so that the judge may, while reading the written notes of argument, he may remember at what point you have submitted and at the time of oral argument. Then the stage comes for judgment. After finishing the argument, the judgment is there. But before judgment, there is one section 236 section wherein previous conviction has to be taken into consideration. Now, what is this section 236? This comes into play only when the judge comes to the conclusion that he is going to convict, or he has come to the conclusion that it's a case he is going to end in conviction. So at that time only the previous conviction will come into play. At that time, the charge of previous conviction has to be read out. Up till then, the prosecutor cannot take the benefit of previous conviction. Kindly remember, prosecutor, you cannot take benefit of previous conviction to prove your present case in hand. Only when the case ends up, judge coming to conviction conclusion, then only this charge has to be read out. And then if the defense denies, then evidence has to be adduced so far as this previous conviction is concerned. And this will only help in arriving at a point as to how much sentence is to be given to that accused, because he has already been held guilty by the court. And therefore, friends, these are the points while conducting a trial before a court of session. Now, the second aspect of the today's matter is of trial of, there is another aspect of trial of warrant cases by magistrate. Now, without taking much time, once you understood what is the procedure and how a session trial is to be conducted, the trial of warrant cases before a magistrate is having the same procedure, except the fact what I told you, that in session court, prosecutor is the sole authority to conduct the case. But in trial before a magistrate, although the warrant case procedure is the procedure for session case, but there is a section wherein the magistrate can have power to direct any person, section 302 CRPC. The magistrate has power to ask anyone to conduct the case, except the investigating officer who himself has conducted the investigation. So this is the basic difference. Now there are two factors. One, in trial of warrant cases on a police report. That means a charge sheet is submitted, which I have already narrated to you how a charge sheet comes to the court. And if the police doesn't take the cognizance of your case, then you have to file a private complaint, and that private complaint is to be treated as case instituted otherwise than on police report. So a police report case means a charge sheet case, otherwise than a police report case means a private complaint case. So before a charge would be framed in a private case, you have to adduce evidence. You have to convince the court. Before framing a charge, you have to adduce your evidence. And if after getting adduced the evidence, the judge is not convinced, he can dismiss your case. But if the judge is convinced, then he will proceed to frame the charge. If you are defending an accused, you have a right to reserve your case, cross-examination. You need not cross-examine when the prosecution side is adducing the case before charge. You have a right to argue the case, because the judge has to get convinced that the evidence put forth by the prosecution, if no case is made out, if the evidence, if unrebutted, would warrant conviction. That means in simple tone, that the evidence is not helpful to the prosecution, which will lead to convict the accused. If such type of evidence has been adduced by the private party before the charge, then the case can very well be discharged. You can also argue the matter by filing application or merely submitting the court that this is a case wherein no need to frame the charge. So this is the basic difference between the police report case and a private case. Number two, the procedure, if the case is not discharged in a, or other charges are framed, the case is not discharged and the charge is framed, then you can have the opportunity to cross-examine the witnesses who have been already examined before charge in a private case. So you can when which you have reserved the cross-examination, you can now cross-examine those witnesses. The prosecution can again produce another set of witnesses even after framing the charge, and then you have the opportunity to cross-examination. And then the after framing of charge, the arguments and the defense and all these things, they are the same so far as the warrant cases are concerned. The only difference is that the absence of complainant, section 249 will contemplate that the magistrate is entitled having a discretion to discharge the accused if the complaint is absent in private case, if the offense is lawfully compounded and or it is a non-cognizable offense. So the offense lawfully compounded, you have to refer to section 320 of CRPC, wherein the table is given as to which offenses are could be compounded, which offenses could be compounded with permission of the court. Only those offenses could be compounded. And if you want to file an application for discharge in a private case, because of the absence of complainant, you have to first see whether the case can be lawfully compounded or it is a non-cognizable case. And then the stage comes, what are the remedies available to the defense? Because we have been prosecuted, we have suffered a lot, we have attended the dates, and ultimately there is an acquittal judgment. Our image has been tarnished. Then whether law acts for such cases, whether there is any provision for the people, that is accused persons, who can seek some justice from the court, that the person who has prosecuted us should be punished. So yes, the answer is yes. Section 250, you can read section 250, wherein the compensation for accusation without reasonable cause has been prescribed. And if the judge feels that this was not the case wherein there was reasonable cause for the complainant or the prosecution to file a case against the accused persons, in that case, if the judge court comes to the conclusion that the complainant needs to be given a notice and ask to why an action should not be taken against you, after hearing him, if the court still comes to the conclusion, yes, there was no reasonable cause, then the court can grant compensation to the accused person, but it will not exceed the amount of fine which he is empowered to impose. Because the CJM is empowered to sentence 7 years, 10,000 fine, the second first class 5,000 and all, and that limit they cannot exceed. That is to be taken into consideration. You can also file an application and ask for the initiation of proceeding under section 250 with the court. If the court is convinced that there was no reasonable cause, then your application may be considered by the court. So this was about the trial of warrant cases, police cases, as well as private cases. Then comes the third aspect, that is trial of summons cases. The basic difference between the warrant case and the summons case is that in summons case, no specific charge is there. No stage of hearing before charge is there. That means you cannot claim for discharge and all these things in summons cases, because summons cases are the cases wherein offenses up to 2 years are tried. Substance of accusation is to be stated. की तुमच्या विरुद्ध असा आरोप आहे, and a plea is to be taken. A formality of charge is to be done. Now the important thing is that in summons cases, so far as petty offenses are concerned, the accused need not remain present in the court. He can just send a letter admitting the guilt, he can transfer the amount of fine, or he can engage an advocate and ask the advocate to plead guilty on his behalf, and accordingly the plea is accepted by the court. So the basic difference is that in summons cases, so far as petty offences are concerned, the accused need not remain present, wherein in warrant cases, the accused must remain present because there is a stage of framing the charge. And therefore, this is the basic difference. And then comes the case wherein there is also one more thing. Section 257, withdrawal of complaint, which is not there in warrant cases. Withdrawal of complaint is an important section wherein at any stage you have to just satisfy the magistrate that you wanted to withdraw the case. आपण म्हणत नाही का आता भांडणं आमच्या गल्लीमध्ये झालेले आहेत, पण आता आम्ही गुन्ह्या गोविंदाने राहायचं ठरवलेलं आहे, त्यामुळं फिर्यादीला केस काय चालवायची नाही. यू कॅन जस्ट पुट अप an application and you can withdraw the case. That is not available in warrant case. You cannot withdraw the case unless and until you can compound the case. As told earlier, section 320 CRPC offenses are there mentioned, then you can compound, but you cannot withdraw a case. So the basic difference is, so far as the warrant case and summons case, you have to understood the punishment difference is there. In warrant case, punishment of more than 2 years can be imposed, whereas in summons case, punishment up to 2 years only can be imposed. Charge needs to be framed in warrant, no charge in summons case. Presence of accused is must in warrant. Presence of accused may not be must in summons case. This summons case can be converted into warrant case. That means the procedure of warrant case can be adopted by the court. If the offense, the court feels that, no, this case needs to be tried by warrant trial procedure, the court can do that. But there is no vice versa. Warrant case cannot be converted into summons case. And then case, as I said earlier, case cannot be withdrawn in warrant case, whereas case can be withdrawn in summons case. One thing is that the important aspect is that the witnesses which are examined by the prosecution and which the defense has also cross-examined, there is one provision in warrant case. In defense, again you can summon those witnesses and you can take the evidence of those witnesses. That provision is not available in summons case. And although this procedure the judge may not permit, because there are chances of again pinning over the witnesses whose evidence is already taken by the prosecution, cross-examination is done, again defense is summoning the same witness, he is narrating the altogether different story. So he will face the perjury and all these things. So such thing never happens, but there is a provision that defense can summon the witness already examined by the prosecution by way of defense. So friends, this was the basic difference between summons and warrant case. I hope you have understood. And the last is chapter 21 is summary trial. Summary trial, you go through chapter 21, and there is only basic difference is that except the punishment can't be above 3 months in summary trial cases. And the category of cases is given in the table in summary trial, theft cases and all these things of fine not exceeding 1,000 or 2,000. Those cases are given which could be tried summarily, and the procedure to be followed in summary trial is that of summons case and not of warrant case. And therefore, friends, I hope this was the experience of me. I hope that you must have appreciated, or you must have taken care of all these things. You will take care of all these things. I hope that if you go on my suggestions, these are some little suggestions, these are some experiences which I have gathered from my long tenure of practicing 32 years. You can add your experiences also, and the day will not be far ahead when you will be sitting in the chair in which I am sitting, and you will also be in a position to guide the new advocates who must have entered at that time. I wish you all the best and a bright future. Thank you.
Thank you, sir. Sir, we'll be now taking some questions. Uh, with your permission, sir.
What is the? Yeah, yeah.
So first question is it's a long question. I'll make it short. It is regarding delay in FIR. So the question is like supposing a person is assaulted by 3 to 4 persons, and the person who's assaulted is fearing because the persons who assaulted are well-known persons in the locality, and then for few days he remains quiet, and then after 10-15 days that person goes to the police and says that I want to file a FIR for incident which has happened 1 month back. So what will happen to the fate of that case?
No, no, many factors are there because delay in initiating prosecution assumes very much importance because the Supreme Court has held that the delay reflects of concoction of framing a particular persons and all these things. And therefore, there is no hurdle for the police to take cognizance of the delayed FIR also. The only thing is that one must explain as to why the complaint was filed delayedly. If the explanation is proper and if the explanation is mentioned in the complaint itself, then if the explanation is proper, then the court will also accept the explanation. Many times there are also chances of falsely implicating the persons, and therefore the court has to strike the balance between these two as to whether there were chances of concoction or whether, as you said, it was delayedly filed because of the fear of the persons. So the circumstances has to be quoted in the complaint as to why you could not file, because it is not necessary that you should get feared yourself and conceal your thing. Nowadays, because of the technical era and all these things, you can email the police authority. The police authority, after receiving the email and all, they will come to your place. They can take your FIR. So all these things are nowadays they are made easy. You can telephonically ask to the control room. You can narrate the your complaint to the control room. They will take action. They will accordingly inform the concerned politician. Concerned politician may come to you. So these are the ways, and therefore, while judging whether really it was a delay because of fear or whether there was room for him for concoction, has to be taken care by taking into consideration the facts and circumstances of the case.
Thank you, sir. So the next question is regarding admissions. So the question is, I'll sum it up, is that in bail applications, the admissions made in bail application, can that be one of the factors during the trial? Say the judge will say that तुमच्या bail application में तुम्ही हा admit केला है, so then you cannot deny, you are stopped from denying the same in the trial.
No, no, those cannot be the admissions because you can take defenses, we may various defenses, you can try for various defenses. So a bail application itself not a piece of evidence, and therefore that was the contention raised by the advocate by taking instructions. So the prosecution cannot take advantage of the contention in the bail and fix up the liability.
Thank you, sir. The next question, sir, I think it is a question which will take entire lecture. So I'm skipping that. That is different between culpable homicide and murder. Sir, if you can summarize in 1 or 2 lines, I know it's very difficult.
No, no, that needs very long time.
No problem, sir.
But yes, the only thing is that the intention and knowledge has to be taken into consideration. If it is done with intention to commit murder, because you have to go through the definition of Section 300, and if you minutely go through the definitions of Section 300, subclause 1, 2, 3, 4, then you will come to know what is the difference between these two things. And therefore, I quoted the example of Salman Khan case, wherein charge under Section 3042 was added, or rather, he was charged for culpable homicide not amounting to murder. So that was the case wherein it was alleged that he was drunken, and therefore a person having being drunk knows the fact that because of drunkenness, he will lose the control over the car, and thereby he may cause the damage to the people at large. And therefore, the knowledge factor comes. And therefore, when there is a knowledge on the part of the culprit, but there is no intention to commit murder, but somehow the fellow has died, and that's why accordingly he was tried, and under culpable homicide he was also convicted. However, in appeal he was acquitted, but that was not the point. He was acquitted on some other points. So basic difference, knowledge, intention has to be taken into consideration, but it needs elaborate discussion so far as pointing out difference between these two.
Correct, sir. Sir, next question is evidentiary value of hostile witness. Can he be relied upon or completely discarded?
No, no, no. Nowadays, the law has been developed. Hostile witnesses cannot be totally discarded because on what point he is hostile? Because he supports the case of the prosecution on a particular point. Then the prosecutor may take advantage of that part of his deposition, and the defense evidence may take the admissions given by him. That does not mean that totally his evidence has to be discarded. It depends upon the facts and circumstances of the case. But the law is that he can very well be acted upon if the circumstances show like that.
Sir, next question is kindly consider that the participants are very raw. So the question is a little elementary in nature. So the question goes by the question says that process issue, can it be stayed, cancelled, and by the same court can cancel it or higher court, so on and so forth.
After process issue, section 204 CRPC, when the judge is convinced, looking to the facts of the case, that there are circumstances which needs to take cognizance of the matter, he issues the process. The only option available for the defending person is to file revision under section 397 CRPC, and then you can challenge that process issue order. The same court cannot take. Earlier it was of the view in Matthew's case that you can file an application before the court and you can ask the court to go back with the order. But now it is a settled law. The same court cannot review the situation. You have to file revision in the upper court.
Thank you, sir. Sir, so there are two questions which I'm combining. Basically, it's about the forensic lab report and CA report. So, what the question says that whether these two reports can be challenged and in what manner it can be challenged.
Yes, yes, you can certainly challenge those reports, but there is a presumption in law regarding these reports. But that is not the way that if you want to challenge, you can summon that witness and you can definitely challenge that witness.
And sir, I think this is the last regarding recall of witness. Sir. Nowadays, it has become a fashion that the trend, I should say, correct myself, that the judges closes the evidence of the witness if the advocate who is crossing does not come. So, what is the procedure regarding recalling?
Section 311, recalling a witness. The court has to see whether it is necessary for the just decision of the case. If the recalling of the witness is necessary to arrive at a proper conclusion, then and then only the judge will grant you the permission. So the wording used in section 311 is just decision of the case. So it is for you to convince the court how recalling the witness will help you in coming to a proper conclusion of the trial.
And so the last question for the day is regarding burden of proof in criminal matters.
It is always on the prosecution. Burden of proof is always on the prosecution, but that is an elaborate issue. I think you have also arranged a lecture, evidences in trial.
Yes, yes. Sir.
In that you may get the proper description.
Ganesh Pawar, sir, I request you to express vote of thanks.
Thank you very much, sir. You have elaborately discussed the various trials in criminal proceedings and enrich our knowledge by sharing your experience. I am very much thankful to you for sharing your knowledge with us. Thank you.
As you said in your other question, the complainant is under fear and is not in a position to go to police station in Solapur. He prefers to go to the nearby police station in Osmanabad or Pune, and there he wanted to file the complaint. Can the police decline to do so? Normally, the police will show you that this is not the jurisdiction wherein the offense has taken place. You go to that police station wherein the offense has taken place. But still, the police, if they see that all these circumstances, they can take down the FIR, register it, and but they don't give the number to that CR number, because always there is crime CR number means crime register number. They don't give number because that is not belonging to their police station. So they take the FIR, they register it under 0 number, and then they send it to the police station in whose jurisdiction the offense has taken place. Normally, this we find it in case of the burn cases. The burn cases in the entire district, normally they come to a district place. The lady or the victim in a position to give details about the crime, and if she is asked to go to the place wherein the crime is committed, it is difficult that she may not survive, and therefore there is a chowki maintained in the civil hospital or the government hospital at district places, wherein immediately the doctor summonses the police constable. He takes down the uh, statement of the victim, and then he sends it to the concerned police station. So normally this can be done in order to avoid the consequences. So this is an example which I wanted to give you. The concept is that you should not throw away the victim or the complainant by quoting the reason of jurisdiction, but you can entertain him by filing it under 0 number. So the concept is 0 number is a phrase developed in the police and all other legal fraternities.
Yes, sir. Thank you so much, sir. I think all queries are satisfied.
On behalf of BCMG, I will like to give instructions for tomorrow's lecture.